post-lunch nap? Because FERPA is so exciting to talk about, right? Well, for those of you who don't know me, my name's Dr. Yvonne Catino, and I work in HR. I do performance management, discipline, training and development, and whatever else we need. Today, I'm going to be presenting the first part of the presentation, and Adam Stone, our new university registrar, is going to be taking over for the second half of the presentation. Sorry if I'm a little out of breath, I just ran here. Okay, so let's get started. We're going to talk about the definition of FERPA. Lots of people have different definitions depending upon which area you work. So how many folks here are faculty? Okay, a good number. How many are administration? How many are students or student workers? Okay, 2 in the back. And then this group, I didn't see y'all raise your hand. The counseling center. Okay, great. After we do that, the definition and discussion, we're going to talk about how we maintain compliance with FERPA. There are several serious issues that Adam's going to address that, if not handled properly, may lead into disciplinary action for you as an employee. And then lastly, we're going to talk about roles and responsibilities of what you're responsible for, when you're responsible for it, and why. Okay, little true and false. Exams and term papers are not subject to FERPA. A's. It's okay to distribute graded papers by placing them on a table for students to pick up after class. Anyone think it's true? Gold star. And then I'm not going to read this. I'll let you all read it. True or false? False? Who says true? How many say true? How many say false? Adam?
This is a great question. Oh, my mic is really loud. Can you turn me down just a little bit, please? This is mostly true. So once one person has legal access to the record, once one parent has legal access, both parents have that same access, regardless of custody and divorce and other rights.
But we'll talk more about that
later on. We will talk more
on.
about that. And the rest of the story, you'll hear this again and again. If anything ever, the one takeaway I want you to all walk away with today is if there's ever a question, what do I do? I'm not sure. What if? Call us. So that's, if you learn nothing else today, learn our phone number and feel free to call us if there's any questions.
Okay. Yeah, that came out a little blurry. This is the FERPA statement, privacy statement in colleague. Yes, sir.
Come back to your previous question about graded papers.
Uh-huh.
My department insists that we supply them with our students' papers with their names on them to be assessed. I'm refusing to do this. I'm told I'm wrong. I know they're wrong.
I don't understand. You're giving papers out with student names on or taking them in? How is?
We are required to do assessment in my department of student papers. The person in charge of this in my department wants the papers with the students' names on them. I refuse to do this. Am I right?
There's no grade yet.
No. They're graded.
Okay.
Oh, no.
But your purpose in reviewing these papers is an academic purpose?
It's for assessment. We call it assessment here.
Okay.
I feel that exposes the students unnecessarily.
I would agree with your sentiment, but I don't think that it's a direct violation of FERPA for you to see their name with that information.
Why not?
Because it's an educational objective of the institution. And in performing your duties as an educational person empowered to do that study, you have access, proper access to that information.
I said the same information could be obtained by the university without the name of the student. If it's assessment, you don't have to know the name of the student.
I'm not disagreeing with you in your intent. I'm saying by the letter of the law, I don't know that what they're giving you is a FERPA violation. I'm not sure it's a best practice. I think there's probably a way to handle it without names. A lot of institutions, especially law schools, do what's called blind grading or some kind of a random ID number that's then tied back, and someone has access to that cross-reference key. But generally, I don't think it's a FERPA violation.
Because the institution mandates it?
Doesn't have to be mandated, but if in the course of your doing your job, you have access to that information, it's not a violation of FERPA. To perform the duties that are assigned to you, you need to see this information about students. You need access to that level of student record.
So other students can't see students' papers, but faculty can?
Depends on what you're doing with them. But if it's part of your review process, then yes, that could be allowed under FERPA.
Could be.
How about we
So-
take this up on the next?
We can, but I saw a question coming from over here.
Okay.
I'll repeat it.
Like under assessment, under an academic area, like I know in counseling and confidentiality, but if you're assessing, I assume you're not assessing an individual student, you're doing an assessment for your area.
It's not clear how it's being used, but my fear is exactly that.
Right.
That a particular student,
Because then it becomes your assessment is student assessment for content, which should be under the whole.
I agree.
So the topic was assessing a program or assessing collectively versus assessing an individual's work, and does that change the intent of FERPA? Probably yes. And that's part of what I'm not understanding in terms of your process, so I'm sorry about that. I'm not sure that FERPA directly prohibits it, but I would share your sentiment that you probably don't need to have that and probably shouldn't have that information to do your job.
Well, you know, if you ask the students if we can use their papers for this purpose, several of them say, as long as I'm identified.
So I think that's a great topic. Why don't you contact my office afterwards, and let's have me understand the process better, and we can talk more about that?
I don't know if you want me to do that.
Okay. Well, you're welcome to do that.
Thank you.
Okay. So, every time you go into Colleague, you will access this screen. This screen basically, and granted it's kind of fuzzy up here, but I'm sure you all have seen it. Every time you click OK, you're basically saying, yes, I acknowledge everything that's in this statement. If you violate FERPA and you've clicked this, there's grounds for termination because you've acknowledged it before you went in to access information. So what is FERPA? Family Educational Rights and Privacy Act, aka the Buckley Amendment. It applies to all educational agencies and institutions that receive funds under any program administered by the Secretary of Education. And it grants 4 specific rights to students: consent for disclosure of their records, to see the education record, to seek amendment to that record, and then lastly, to file a complaint if they have an issue about the record. Basic rules. Student education records, or SER, SERS, are confidential. And release of any information requires consent, written consent of the student. And Adam, I believe we have a form that students have to fill out to give their consent.
There's a lot of different forms that students can fill out and will be required to fill out based on what they're seeking to have done. But yes, we have a lot of forms for release of consent. Just real quick, one of the ways of consent, students can waive their right for privacy. They can put on file with the registrar's office that they want their parents to have unfettered access to their records. So if mom or dad calls, we may disclose the information to the parent. We ordinarily would not be able to according to the law, but the student who owns the record has waived that privacy right and has chosen to let their parents see that. They can do that. Another that Yvonne will get to in a second is what I call the Great Divide. FERPA is all about education records for education purposes. Excuse me. It's an academic record for academics. And so the Great Divide is employment. Personnel, employment is not an educational purpose. And so if a student, a former student, wants to get a job, and HR calls and says, would you send me a copy of the transcript? The first question I'm going to say is, where's the release? That's not an educational purpose.
Okay. So as faculty and administration, you have a need to know to get into colleague, to access student information. Need to know is the important phrase. Even though I'm in HR and we have student workers, I don't have a need to know. I don't have access to Datatel, even though we have student workers. Now, other people in HR have access to Datatel because they're on a need-to-know basis.
Let me go back to need to know for a second as well. Need to know, it's a two-part question. As the registrar, I need to know every student's transcript, every student's grade, collectively speaking, because I'm responsible ultimately for the accuracy and delivery of that information. But if Alicia, I'm going to pick on her because she works with me, if Alicia were a student at the university, I don't have the right to go look at her record just because I'm curious to see how she's doing. That's not a need to know. So my need has to be job-related and student-related. So pick a celebrity. If an elected official was a former student at Kean University and we just want to see how he did, no. That's not a need to know, and that's a violation of FERPA. Yes?
Quick question.
Absolutely.
Let's say a student wants me to write a reference letter for grad school. And the student says, can you please write there that I got an A in your class, which is true. And I actually refused, and I said, because I can't disclose your grade, I wasn't sure. But the student really wanted me to do it. Can I?
Yes, you can. But in that case, I would want something from the student. Basically, yes. An email is fine. It comes back to authentication. So if the email comes from a Kean address, you know that the student is who he says he is or who she says she is.
No, it's my student from my class.
No, understood. But if the email comes from Gmail, you can't validate that person's identity. But if it's a student that you know and have access with, and the student has written to you saying, please write a letter of recommendation, by all means, please do that.
Please put my grade in there. Then it's going to come.
If that's what they want you to write, and they've written that to you as an instruction, then basically the question you're going to ask is, if this ever came back to a lawsuit and someone challenged, why did I release that? And you say, because the student wrote to me on December 5th and said, please tell them I got an A. And you're going to produce that paper and say, because the student asked me to, and here's the student's request. You're covered.
Okay.
I'm a little confused about, if we're talking about from the instructor, the student's asking for the instructor to write a letter of recommendation. The instructor already knows the student's grade. The instructor assigned the grade. That seems to be a moot point. We're talking about if the instructor wants to see the transcript in general to get a better feeling for the student. Is that what?
No, I'm saying that I'm releasing his grade to grad school or
She's releasing the grade to a third party who wouldn't ordinarily have access to that.
Okay, then let's take what I said. Suppose the student asks me to send a letter of recommendation. I know I've had the student for 1 or 2 courses. Obviously, I know the grades there. And I have in the past, and I would take the liberty of saying this student finished at the top of the class, or this student was one of 3 A's given, or something like that. When I have access, or if I want if that's the only course I have, and this is an important letter for an important job, I want to get a better feeling for how the students performed in other subjects, do I have access to the transcript based on that?
Would you have had access to that student's transcript otherwise? Were you an advisor for that program?
In some cases, I was the student's advisors. In some cases, I was not. He just a student. who was-
Right, but in your capacity as an advisor in general, that person could have just as likely been assigned to you as not. I would say yes. But again, I would want a letter from the student or something documenting what's being released, because you're furnishing identifiable information to a third party.
I would add, to err on the side of being conservative, always get it in writing and get it from a kane.edu email address.
Absolutely.
Okay, so definition of a SIR. They're directly related to the student, and they're maintained by the agency or institution or party acting for the agency or institution. And that definition is straight out of the FERPA law. However, what do SIRs cover? In attendance for post-secondary institutions, it does not cover students who applied, got accepted, but did not attend. Questions?
So you're saying that if somebody went to college A, was planning to transfer to Kane, they supplied their records from college A, but then didn't come to Kane, those records are not protected?
No, we're not saying that. We're saying that many of those records are not protected, but the transcript from their prior college that was sent here as part of their application record, that's subject to FERPA under the preceding college's FERPA law. So when we issue a transcript, we're getting to some esoteric things here. I welcome the questions, though. When a transcript is issued, it is issued to one person for one purpose. So when Rutgers sends that transcript to Kane, because of course they want to come here, it's a much better school. When Rutgers sends that transcript to Kane, it is issued to Kane University for the purpose of that student's admission record. We are not allowed under FERPA to re-release that to any party. If somebody wants that Rutgers record, they have to go back to Rutgers to get it. And they have to follow the FERPA laws in place for that student at that institution. We can't re-release it. But
I just couldn't think of an example of that other than what I said.
yeah, but other documents, the application form or other pieces of information that might be on file are not technically subject to FERPA.
This gentleman.
I don't know, what's something with people, we get it.
We're good?
Okay.
Okay. So, a student education record comprises a lot of information, more than just your basic demographic information, phone number, address. It includes all of the things listed up there, and perhaps more. Personal information, okay, we can understand that as a directory or student education record. Emails to and from the student, part of a student education record. Financial or disciplinary records. Health data, all covered by FERPA, or in the student education record. Now, media, we've updated this since we delivered it last January. Not just documents, emails, handwritten notes, third-party chat platforms, Google Talk, Trillion, those types of chat platforms, anything that's in there, that's part of the student education record.
Is there a question?
So I did go back to your last slide. You said that emails to and from students
Mhm.
There have been times when faculty or staff will call us at the counseling center and say, I'm concerned about a student, they've sent me an email. They would forward the email to us to get an idea of what the concern is. Is that a violation?
No, because you're acting in your capacity that is charged to you by the institution. So the first part of that, the question is, if an email gets written to, say, anyone, a faculty member, an administrator, a staff person, and there's some cause for concern, the student may be in trouble or harmful or whatever, that may be forwarded to a counseling center or perhaps a bit team or whatever. Is that a violation? No, it is not. Particularly in the cases of, and we'll get it, this is kind of, it's part of FERPA, but it's getting into some of the darker parts of it. Anytime there is reason to believe that there's danger or threat, and this is particularly important in this day and age because we see it more and more on college campuses, if there's any thought of danger or threat, and you believe that releasing information about that student will save property or lives, FERPA be hanged, release it. Document it and why. But I hope this never happens, but I have been at a university where it did, and so pardon me for getting choked up, but it's part of my fabric where a shooter came on campus. You see a student with a gun, and you have reason to believe that releasing something about that person's history or information would save someone else's life, do it.
I'm a licensed counselor, and we are asked, we're mandated to use encrypted WhatsApp communication. Is that also part of FERPA?
If it's about a student, the question is if the correspondence is encrypted or somehow else secure, is it part of FERPA? If it's about a student's education record, as Yvonne described it earlier, yes, it is discoverable under FERPA. If a student says, I want to see that record, we have to open it up. So there are no secrets. If you are in colleague and type a comment about a student, it's discoverable. Anything that we transact or communicate that's written down is discoverable under FERPA.
How about platforms like Blackboard?
Yes?
Yep.
The
Any
question
messages?
is Blackboard, if you do correspondence through Blackboard, messaging through Blackboard, commenting in Blackboard, is that discoverable? Yes.
What if we communicate with a student, that student then shares it with someone else?
That student has the right, the student owns their own record, right? So if that student chooses to share that with somebody else, that's on the student.
Mm-hmm.
Do the students get to see that automatically, or do they have to give them a time frame?
We're going to get to that. That's a great question. Does a student get to see these kinds of correspondences automatically, or is there a time frame? Students have to request access to inspect their records. So that's part of the FERPA Act, that if a student wants to see their record, they have the right to, but they need to make a request, put it in writing, and there's a period of time that the university then has to respond, and there's a vetting process in terms of which office then is the custodian for that part of the record and will work with the student to allow access to inspect that part of the record. And that could be a variety of offices depending on what the student is seeking to learn.
Okay. So a couple of areas that we added from last year are social media postings, the third-party chat platforms, and comment fields. If you're in colleague and you enter in a comment on one of the screens on the student's record, covered. You're in an Access database that you have and you enter in some comments about the student's performance, covered. You're on Facebook and you happen to see a student's comment, you connect with a student and you put a post on the student's Facebook, covered. Covers a lot. Okay?
Yes?
Is that if you connect with some medium in your capacity as an educator, is that what is covered, or is it always at that relationship?
Because the question is, does it depend on your capacity, having worked with the student as an educator, and your purpose in going into Facebook may be purely social, it had nothing to do with your academic history with the student, is it still covered? Yes, because you're still a university official. So the rest of that question is, if I go out to the bar after class with some of my students, in this social setting, am I free to discuss things about other students? No. I'm still a university official and am seen by the students as such. And so the venue does not change that relationship, that posture.
I've heard that there is a kind of law that if you see some kind
The question is, if you see something in social media or someplace else about a student that may be illegal or on the fringe of legality, do you have to report it? I don't know that. That's not a FERPA question per se. So FERPA doesn't really get into that I know about. I have not been faced with that question yet. So if that does present, call me and we'll research it together and find out. That doesn't mean there's not other rules that require you to report that, but it's not as far as I know, it's not a FERPA specific question. Yeah. Who's in the booth? Is that Carlos? What time is it, please? 2:08, thank you. Okay, so I'm going to move a little bit quickly if I can. We have a lot of slides yet to go. Only 200 more slides. You'll be fine. So we talked a lot about, thank you, about what is a student education record. There's a few things that are not. Medical records, if it's specifically a medical record, health services, that's HIPAA. That's Medical Act, not FERPA. So if you go to the health center about this mysterious rash, that's not discoverable under FERPA. Personal notes that only one person has taken and only that same person has access to. I am the instructor and I wrote a seating chart or made personal memory aids about my students and nobody else can see them because I locked them in a cabinet that no one else has a key to. That is not part of FERPA. That is separate from FERPA. You can do that and that will not be discovered because it's personal records. Work records, we spoke about that a little bit ago, about employment, HR, and academics, the great divide as I call it. There's an exception to that. The exception to the exception is if your employment status is contingent on your being a student. You're a graduate assistant. You cannot have this job as a graduate assistant unless you're enrolled in a graduate program. The minute you drop out of school, your employment status must end. Your employment status is directly and completely linked to your student status. That then becomes an education record, and so the supervisor has access to your academic record and vice versa. So that's a blending. Same with college work study. Your employment status is dependent, entirely dependent on your being a student. Question?
Let's say HR agency, you know how they have HR agencies out here, that's like students. They call and say, John Doe, I want to confirm John Doe graduated.
Okay. The question is if a hiring agency or a recruiter comes on campus and wants to confirm some information about students, can they do that? Hold that question. It's a great question. I'll get to that. The last exception is alumni records. What happens after you graduate? You donate lots of money to the library? Great. Not protected under FERPA. Okay, so here's the great thing about FERPA. As I like to say, oh, I'm clicking all kinds of things, aren't I? There we go. Okay, may not must. FERPA says we may release information about students under certain circumstances. FERPA rarely says we must release information about students. We're going to get to directory information in a second, which was your question. But keep the rest of these slides in the context of we may, not must. So we have this thing called directory information. What does directory information mean? There are certain things listed in the FERPA law that says these are deemed to be non-damaging. They wouldn't hurt a student if this was released to some outside person or agency. And those things tend to be like your home address or your phone number, whether or not you got a degree would be a great one. What's your major? Did you study history? No, yes, no, it was biology. Those kinds of things are not generally damaging to a student if we were to release that. And so FERPA has this carve-out called directory information that the university may release, not must. So right now, the Kane University policy allows these particular items to be released. You should know that we are in the process of reviewing that. I don't know if this is going to change in the upcoming year or not. If it does, it will be tied to the catalog, which comes out in the fall. But that remains to be seen. But until then, this is the list of things that we may release without a student's prior consent. So if someone calls our office and says, hi, I'm from this recruiting firm, did Alicia get a bachelor's degree? Yes. Bachelor of Arts. What year? 2014. What was her major? History. What was her GPA? Can't go there. But I can tell you that she graduated. It was a BA in history. Okay, what else have we got here? The exception to this, though, is students have the right to block their directory information. And they are notified of that right in the catalog. And so students may come to the registrar's office and fill out a form that says, I understand that directory information can be released about me. I don't want you to do that. They can put that form on file, and now none of this gets to be released. So what can be released? A lot of, this is, okay. So this is back to the main line of FERPA, not the directory pieces. Student grades, GPAs, disciplinary actions, whatever. What can we release without a student's prior consent? Anyone who is an employee of the university who is tasked with a certain process. You are the student's advisor. Of course you need to know the student's academic history in order to provide the proper advice. Maybe this is not even the right major for the student, or maybe it's a great major. Maybe you need to take more challenging courses. But how can you possibly do your job without looking at the student's history? Yes, you need to do that. That's part of what FERPA allows. Other schools, this is an odd one. It doesn't usually happen in real life, but it is allowed for. If a student, perish the thought, wants to leave our great institution and go someplace else, and so as part of the application record to St. Peter's College, St. Peter's University, can we release information about the student without the student's consent? If we know it's for admission purposes, yeah, legally we can. But again, may, not must. Legally we can. In practice, we probably don't. I can think one time in my career where I did because a student applied to a law school and forged my signature, thank you very much, I take that very personally, as part of a letter that I didn't write about his great academic history, which he didn't have. And so part of FERPA allowed me to call that other institution and say, is my student an applicant at your university? I never wrote that letter. So that's where that tends to come up, and sometimes it is for good purposes, not nefarious, but it does allow for that. Accrediting bodies, review bodies, auditing bodies, there's all kinds of agencies that come in. So for example, we will be audited on our financial aid records. We gave out student financial aid, and the auditors will want to see that these 100 students, and they will specify by name and by ID number, these 100 records, they want to see transcripts. Can they see them? Yes, they can. They are auditing them for our educational purpose. They are allowed to have that. Audits, like I said, school employees with a need to know. We talked about that earlier. You don't get to just go around snooping. There has to be a real reason for it. So while I have access to all grades, I don't get to look at all the grades. But if a grade change crosses my desk, it's my job to record that. I get to look at the old and the new grade and put that into the computer. Safety emergencies. I talked about this a little bit ago. If there's some kind of a health or safety emergency where you believe in your best interest that it's in everybody else's best interest to release something about a student, that is an exception that has always been part of FERPA. You are allowed to do that. And I hope it never happens, but if it ever happens, please do. Health and safety of our community comes above all, right? Sex offenders, legal actions where we're defending ourselves. Solomon Amendment, I would say virtually none of you will deal with the Solomon Amendment. It allows the military, branches of the military to request of the registrar's office certain lists of students, which we do or don't furnish depending on how they have worded that request. But military recruiters are allowed to see certain pieces of information that other parts of the general public would not be allowed to see. Parents. We talked a little bit about parents before. Can parents see that? Again, may, not must. So if a parent has, am I blocking your view? I'm sorry, I'm realizing. If a parent has listed their child as a dependent on the tax return, then does that parent, can that parent have access to the record? Yes. In practice, we don't typically go pull tax returns to see if the person on the phone has filed on a tax return that student as a dependent, so we tend not to give that information anyway, but we could. Again, and it goes to both parents. If either one parent, the parents are not together, the tax return may not be joint for 100 different reasons. If either parent claims this child is a dependent, both parents have access per FERPA. But again, in practice, probably neither parent would be allowed to see that record.
So if the student is not a dependent of any of the parents, then the parents cannot see.
Right. So the question is, if the student is not claimed as a dependent on any tax return of anyone else, can a parent see the record? No. No. But in practice, we probably would say no anyway. We would still want that release. The student is our primary customer, our person that we are working with, and so we really kind of want to.
Well, sometimes parents like send emails, oh, what's going on, why my student doing this and that, etc.
Oftentimes, parents will write to various members of our community asking about their child's performance in class, and I would always err on the side of caution and say, I really can't tell you. But I have told many parents, and this, I don't happen to have children, but if I did, and if I were paying thousands of dollars a semester to send my son or daughter to school, what would I do? Okay, I'm paying $10,000 a semester or whatever it is. Every semester, you pay $7 and bring me a transcript. Seems like a fair return on your investment. So I would advise parents to do that. But again, that's up to the student to request that transcript and issue it to their parents. Whether they do or not is not ours to control.
I've always heard students can sign a waiver or something so that they can allow their parents
Yes.
access.
Yes, I talked about that earlier. Can students sign a waiver granting their parents access to FERPA to non-directory information? Can students sign a waiver letting their parents see their academic information? Yes, they can. That's on file in the registrar's office, and we are happy to work through that process. I'm sorry? It is on CaneWise, and there's a very cryptic screen, XSCR, I think, something like that, where you can see it if you have access to that screen. Again, if in doubt, call the registrar's office.
All this is very helpful for us in this room. But the persons most affected by this are students. I doubt they're aware of all this. What does the university do to make them aware of it?
Well, that's a good question. So the question is, what does the university do to make students aware of their rights? Because this is really centering on the student and the student's rights. We publish the policy on our website and in the catalog. We all know that if it's more than 144 characters, students won't read it. And this is a lot more than 144 characters. So no, students don't read that. What I'm planning to do is, starting this spring semester, is start an email campaign just letting students know, here's the FERPA policy, here are your rights, just to kind of push that out and take a more proactive stance. Again, will the students read it? I don't know, but I want to at least be proactive and try to put that in a medium that they'll see.
You know, my son just graduated college. Every student in his institution is required to attend a session like this to learn what their rights are.
That might be a good topic for our T2K courses. I haven't gotten that far yet, but that's a good suggestion. Back to what can be released. I'm going to skip over that. It happens, it's sad when it does. According to FERPA, your rights die with you. So if a student is deceased, and Kane has been around since 1855. Many of our students are, in fact, from 100 years ago, are deceased. Are those records protected under FERPA? No, they are not. But we have a protocol. Just because they're not protected doesn't mean that we don't have protocols. So we would still want to see a death certificate, next of kin relationship, and so forth. Again, should that ever happen, contact the registrar's office. Parents, we talked about parents. I think we've covered this quite well. Am I ahead of myself? There I am. I'm on the right slide. Are there any questions about parents with access? Or can I move on? Yes?
So this says that if they are a dependent, they have rights. The only time that they need to fill out a waiver is if they are not listed as a dependent?
No, I'm not saying that. It's always best for the student to fill out that waiver if they want their parents to have those rights. Because in practice, getting those tax returns is not an easy or immediate process. That's part of a financial aid file that the registrar's office typically doesn't go into, and certainly faculty offices don't go into. So in matter of practice, we typically say, don't know that you're filed as a dependent, I still want to release. So again, that may, not must. We may release it if they're a dependent, but we don't have to. Better to get the waiver.
So a parent could come and say, they could provide the evidence, even though we've got no waiver on file.
They could.
Would then be obliged to share
Not obliged.
despite
We are not obliged. We are never obliged. We are not obligated to furnish that information. We may furnish the information.
That waiver is another reason to actually see the students face to face, so they know about this waiver.
Yeah?
Otherwise, they're not going to read line 16E.
You're right.
If you really want to protect the students, that's what you got to do.
Well, the waiver takes away the student's rights. That's the student giving away his or her rights. So that, what's that?
Exactly.
So,
But they may assume the parent has a right.
they may. They'll find out otherwise. I'm not disagreeing with you. I've been here not even 6 weeks yet, and there's already some changes I've made with regards to FERPA. I'm looking at the directory information list. We're looking at more proactive communications. And I'm taking your suggestion very well at heart. I think it's a great suggestion to find other ways of getting this information in front of students. It just hasn't happened yet. But I think it's a great idea. We've talked about not on tax returns. There's a form. There's a link in the packet. You'll have access to this packet online. Do students have rights to inspect their records? We talked about that earlier. Yes, they do. They need to contact a school official. It needs to be routed to the correct school official. We will work with the student to ensure that that happens. There's a whole calendar of time, I think it's 45 days, believe it or not, that we have to respond to a request to open up records to the student. If you ever get a request under FERPA to open up a student's record, please contact the registrar's offices because there's a whole host of things that have to ensue based on that. So we want to be sure that we're totally and institutionally compliant with such a request should that ever happen. Yes. Well, that's the question is, does the student have a right to see everything in their file if they make such a request? That's part of why we want to see that request when it's written, because the request has to be specific. I want to see whatever. It may be a financial part of the record. It may be an academic part of the record. So we are not obligated to furnish things outside of the student's request. If the student says, I want to review my student account, that doesn't mean we have to open up the academic folder or the registrar's file to them. But if they're asking to see communication regarding whatever, that it's a horse of a whole different color, yes, we may have to open up more and different things for that kind of a request. And yes, redaction is part of it. If other students are named, let's say there was a judicial process or disciplinary action where 2 or 3 students were involved in some whatever situation that happened, and student A wants to see that part of the file, the names of students B and C have to be redacted. The student A may know who students B and C are, but they don't get to see that in the report as such. That all has to be redacted out. Insofar as the request says yes. Yeah, which is why we were so cautious at the front end about what is FERPA, what's a SIR, what is protected. A lot of things are discoverable. One of the things, I'm going to kind of go a little bit off slide here for a quick second, is how are we doing for time, Carlos? Seven minutes. We can do this. Only 15 more slides. So the question is, do we have to keep every piece of information? No. New Jersey has laws about what record retentions there are, what documents we have to keep, and how long we have to keep them. But if it's not covered under a certain part of New Jersey law that says we have to keep a certain document, think about it. What's the benefit to the institution or the student by keeping it? I'll give you an example. One of the institutions I used to work at happened to be private, and it was not in New Jersey, so the records laws were different for that situation. But a student who was actually a counseling student wanted to have an appeal to withdraw from classes late in the semester and have a financial consideration given as well. So a late withdrawal and refund kind of a situation based on medical health related reasons. And the medical information that she provided was that she had a psychotic break. I didn't see the benefit to anyone discovering that particular diagnosis later on in the student's career. So that whole documentation set came in. We reviewed the whole packet. The student's letter requesting the consideration was put on file, and the registrar, yours truly, annotated that document saying medical documents were verified, provided, verified, and destroyed. And they went right through the shredder because I didn't see any value to the student to ever have that document come back out in a FERPA situation. Now, New Jersey law may be different. We may have to keep certain documents. I don't want to just be foolhardy and destroy everything, but do consider, do we have to keep the document? Is it essential to the student's record?
College requirements students with their ID numbers to verify how it's
Yes. So the question is ID numbers. That's a great question, and that's been one of the recent changes of FERPA, that student ID numbers are allowed to be part of directory information. That's one of the changes I plan to make, that is explicitly written in our policy, that student assigned ID numbers are open record. Because you can't do anything with that ID number unless A, you have access to transact whatever you're transacting for any other student, or B, you have the password that goes along with it. You're the student, you have a password. No other student can pick up an ID number and transact on the first student's record. Failure to follow FERPA. If you don't follow FERPA, bad things will happen. That's the takeaway from this slide. There can be a lawsuit to the university. We can lose our Title IV funding. You personally can be sued. The institution may or may not be able to protect you from a lawsuit, should there be one. Do be aware of that. So if in doubt, don't release it. Clicker is not clicking. USB input device. Well, when you go back to your office, you will have access to a copy of this via the university's wonderful website. And there are further links in that, including a YouTube video that you may find interesting. It's not terribly long. It's another institution that did it, but they posted it on YouTube, so it's public consumption. So you may find that delightful. Your role is to protect student information. If you're in doubt, check with the supervisor or check with the registrar's office. Yvonne has also offered her services, so if in doubt, you can contact either Yvonne or me, and certainly include your supervisor in that conversation. If you have access to student data, you have to acknowledge that you understand and are going to abide by FERPA every time you log into the system. Ask yourself if retaining a document is necessary or important. The registrar's office is tasked with being the compliance office for FERPA. So again, any questions, we're happy to field them. A couple of last minute questions. Directory information pertains only to students' names, addresses, and phone numbers. Is that true or false? True? False? False. Directory information pertains only to students' names. Oh, I just did that one. Parents are allowed to see their child's records. Just in the general statement, parents are allowed to see students' records. False. There are lots of caveats on that. In some cases, yes, but there's lots of conditions. So blanketly, no. Faculty have a right to see education records of any student attending the university without giving a reason. False. If you could see the last slide, it's certainly in your handout and it's on the website when you get to there. You'll see my name, email address, Yvonne's contact, and a link to the copy of this presentation. You have a question, sir?
I collect student papers at the end of the semester. Most of them don't do well. They're in a file. I've not been given a key to lock my file at the institution. If someone breaks into my office and takes those papers, am I liable?
Good question. That's going to depend on how it comes out in the case. So the question is, if there's papers in your office or in your control someplace, and someone breaks into your office and takes that information, are you personally liable for that?
So you're saying if someone had the computer and got all the information, then you won't.
That's the question. I've never seen that question challenged in court. I don't know how the courts would decide on that. There's a central agency in Washington that Yvonne talked about in the first or second slide. It's called the Family Policy Compliance Office. They're the FERPA police, if you will. That's where all cases are referred at the federal level. Yes, there is an office that's charged with doing nothing else. God help them. They would certainly be brought into that case to discover it. I would recommend locking your office.
As I say, I'm requesting a key to lock my files for 2 years. I've never gotten it.
I understand that. Do you have access to lock your office?
The office is locked, but if some maintenance person goes in there, they
So-
can open any file and throw it out.
Correct, if maintenance goes in, but that comes back to FERPA writ large. Okay, so the question is, whose responsibility is this? Everybody's. So if housekeeping,
Subcontracting.
if housekeeping walks into your office to take out the trash and you have a student's test paper sitting on your desk, are they obligated to keep that confidential? Yes, they are.
Do they know that?
Don't know.
See, we were originally told that we're going to have keys to our offices for the reading.
Do you know for how long do we actually have to keep all the tests and?
I don't know that. That's part of New Jersey records retention, how long you have to keep documents. And I don't happen to know, that's separate from FERPA. So the Jersey retention policy is very different.
If a student opts out not to disclose their directory information, and faculty cannot contact the student via email, can faculty contact our department for an alternate email address for a student?
If a student, the question is, if student opts out of directory information, can other university officials use that information? The directory information is only for third parties outside of the university. The university is never prohibited from doing its business. So directory information and other information, if you need that information to do your job, if a student puts a block on for directory information, that doesn't affect you. It just affects what you can release to someone outside of our walls. But if you, the faculty member, says, I want to write an email to the student, even though the student blocked their email address, you write that email. You go right ahead. That is your job.
But if someone asks me for information on how to contact the student, I should stay out of it.
Then you should stay out of it. Which we generally do anyway. I've had lots of requests over the span of my career where I've given this example. You know, Susie calls up and says, you know, I used to be a college roommate with Nancy, and I'd love to get back in touch with her. Can you give me Nancy's home phone number? What I'd be happy to do is take your phone number, Susie. I'll call Nancy, and if she wants to call you, she'll call you back. Go ahead.
I was under the impression that at one point in time, students had to fill out waivers for every department. A lot of departments, like student accounting had their own waiver, financial aid had their own waiver, all these different departments had waivers. So now, it was my understanding that all this stuff was combined into one universal university waiver, that you could go online, but I cannot find it anyway. How do we verify that a student has granted a waiver for their parents or anybody can see the record?
So the question is, do different departments have, you know, different waivers? Are we siloed, in other words? That piece of history I can't answer. That predates me. In other universities where I've worked, it's pretty much been one size fits all. If a student grants the release, anyone may, not must, go ahead and give that information out so far as it's compliant with the waiver that's on file. But the second part of your question is, how do we find out if there is a waiver? Two ways. If you have access to the computer screen that shows it, which I think is XSCR, I think that's it, something like that. If you have access to that screen, you can look it up. I believe that's it. If that doesn't work or you don't have access, and in any case, if you just want to call us for verification of that, because it's not the easiest screen to read, call 73101.
Parents that call me and they want to know about their students' bills or whatever, or how come they didn't know the bill was due, how much is due. student, I tell them I can't tell you anything because FERPA.
That's
So
the right
how
answer.
do I verify that the parent, and I said, well, did you sign, did your kid sign the waiver? Oh, yeah, Johnny signed the waiver, so I can't prove it.
You can call us and we'll verify that to you. Okay, so I'm hearing that many departments don't have access to that particular screen. That might just be a registrar's screen. But so if you're one of the lucky 3 offices or 4 offices that has it, great, use it. But if otherwise, just call us. Well, that's it. Identifying, verifying the identity of a caller is hard to do. So we tend not to give too much information over the phone anyway.
Who owns this, to get back to something earlier, who owns the final exam? The student? The instructor or the student?
Who owns it? That's a,
The student wants it. Does the student have a right to take it or just seek it?
that's up to faculty policy. Who owns it? I'm going to give you a very complicated answer. My belief is that the university owns the medium, the student owns the information on it. So the student has a right to see it, but the,
Completed the final exam?
Yeah, they completed the final exam.
Why would they not have a right to see?
I didn't say that.
Well, it's just a question of whether they have the right to take it.
Can they have that copy back for their,
Okay, how about the, so it's fine.
That's what I get it, because you know,
The original final.
5 years to 5. Now, what is seminar are open, they say that, 5 years to 5.
You are 5-year-old.
Yes,
I have 20-year-old exams too.
I say in the syllabus that it gets destroyed at the end of the term.
Smart.
The final the children,
And then the final exam gets destroyed in the middle of the following term. It would be like the Collier brothers dying every 5 years.
right? But the student has a right to see it, of course. No one's challenging that. But can the student walk away with that copy in hand? I would say no.
Copy it, of course you have a right to copy it, the student's supposed to.
That's up to you if you want to furnish the student with a copy. FERPA allows under some circumstances for students to have copies of their records, but FERPA does not require the university to furnish copies. But you may. If a student requests to have an email of their final grades, can you do that? Again, it's protected information under law. Can you furnish it? Personally, if the student asked me to do it, I would, but only to their Kane address. If they say, please write to me at susieq@gmail.com, I have no idea who that is.
Nowadays, the grade turnover is so rapid, there's no reason.
Indeed. Yeah, I mean, you post them online, we verify them,
And they're up to 24 hours.
often less. We actually run the posting process 2-3 times a day, frankly. So we don't get up in the middle of the night to do it. So if you do them after we go home, we'll do it first thing in the morning. But to your point, yes, it's well within 24 hours. We run that process as frequently as we can because students want to see it. But yes, if a student wants to see it, that's their information. They're allowed to know it. There's nothing stopping you from releasing it if you feel so inclined. But I would want to verify the identity of where I'm sending it. So the Kane email address is your protection. Other questions? So thank you for all staying awake, especially after lunch. I hope it was. Thank you.